Greetings to everyone. Welcome, candidate. Advisory group of experts gathered today to interview Mr. Konstantin Krasovskyi, a candidate for a position of a judge of the Constitutional Court of Ukraine, who was admitted to the competitive selection under the quota of the President of Ukraine. Mr. Krasovskyi is a lawyer and is currently serving in the armed forces of Ukraine. We are ready to start, so I will turn the floor to Secretary of the Advisory Group of Experts, Mr. Jaroslav Romaniuk, to explain the procedure of interview and to moderate it. So, Jaroslav, please.
Thank you, dear Mr. Chairman. Hello, greetings, Konstantin Yurievich. I'm greeting everyone who's watching our broadcast, and I would like to greet everyone with today's holiday with the Ukrainian statehood. Thank you so much. Konstantin Yurievich, today at this interview, this interview is being attended by the members of the AGE, and that is the chair, Mr. Alice Zeller, the AGE members, Maureen O'Connor, Hanna Sukotska, Oksana Vasilchenko, the AGE member Vasil Shakun, and myself as the secretary of the AGE. Also, 5 deputy members of the AGE are present, Mr. Richard Barrett, Marek Zubik, Volodymyr Kuzmenko, Vitaly Makhinchuk, and remotely, distantly, watching the work of the AGE, Mr. Thomas Griffith. I will briefly explain the regulatory framework and the procedure for conducting interviews. The interview is one of the mandatory stages of assessing the criterion of high moral qualities of candidates for the position of the judge of the Constitutional Court of Ukraine. The advisory group conducts interviews with candidates in accordance with Article 7 of the methodology, in particular to clarify and refute any doubts about their high moral qualities. So this is in your interest, Konstantin Yurievich, for you to refute some of the information or to refute some doubts, probable doubts that the advisory group of experts had in part of your integrity. While processing the materials on you, Konstantin Yurievich, the AGE sent you questions for written explanations. So you had the opportunity to prepare and provide answers, and you did that, and we are grateful for this, for the communication with the advisory group of experts. In this context, I would like to draw your attention to the fact that according to Article 7 of the methodology, a candidate may not provide information, documents, or other materials during the interview now if the advisory group has requested them earlier and you did not wish to provide them within the specified period, or if you decided to provide this information now, the one that you haven't provided before. But we may make an exception if there are some reasonable reasons. I would also like to inform you that the interview is being recorded and it will be broadcast live on AGE's resources and on the CCU website. Therefore, I would like to draw the attention of the AGE members and you as the candidate for the position of the judge in the Constitutional Court of Ukraine to restrict the use of sensitive data and restricted information during the live broadcast. And we have the intention to ask such questions. That's why we will stop the live broadcast so that this information is not disclosed. Clear, thank you. Konstantin Yurievich, I would like to draw your attention to the fact that the interview will last approximately 1 hour, and the time limit for answering questions is up to 3 minutes. That's why I will ask you to be laconic, brief, to the point, At the end of the interview, you will be able to make a short closing statement of up to 5 minutes. If your level of English is not sufficient, you can use the headset. The blue light means that the simultaneous interpretation is ongoing into the state language. And this is due to the fact that many of the experts will be asking questions in English, since they do not know the state language. Is it clear? Yes, it is. And now we are ready to start the interview with you, and allow me to start and ask you some questions. In your declaration for 2014, you did not specify any object of property that you would own or rent or lease or any other use. Where did you live at that time? Thank you for your question. If I understand you correctly, you're asking me personally that I did not specify any property. Yeah, but you did live somewhere. Yes, I indicated in the declaration place of residence, City of Kiev, the street Drazira, apartment 36. In part 2, place of residence. I see. And in the declaration per 2015, you specified that in March 2005, you gained the rights of use the car Chevrolet Aveo 2005. Altogether, this data was not present in your declaration per 2014. Why didn't you specify this object in your declaration? I did mention in the declaration of 2015 about this object, since I learned that I had the rights for this car in 2015. So being vigilant, and I wanted to submit this information in the declaration, that's why I did this. I see. In September 2017, your wife purchased an apartment of 77.4 square meters located in Kiev. The apartment was valued at almost 94,000 USD. And you have explained that almost half of the funds were received by your wife as the gift from her mother. Could you please explain the origin of these funds? Where did your mother take this money? Sold the apartment in Dreiser 36, apartment 106. So she owned that apartment. So she sold her own apartment, and she gave this money to your wife. Yes, she made that gift to the wife without. Yeah, this was like an assistance, like a family assistance, and I specified this in the declaration. Okay, as for declaration, in 2019, you have declared the amount of the gifted by your mother to your wife funds, but you have declared as financial liability. So a gift does not presuppose any liability to the one you give it to. In the declaration per 2021, this liability vanished. So how can we understand this? Whether this was borrowed, lended money, and why is it first gift and then it's a liability? So should we consider this, that the funds were returned to the mother? Thank you for your question. If I understand you correctly, you said that as the financial liability, but in the declaration it says support to the family. That's how I declared it. It was the support or assistance to the family, but this is no liability. Maybe the liability is to return, to repay, but a gift does not presuppose any liability. In 2017, that's how I, assessed this as assistance to the family. I see. On the website Prava.ua in April 2022, there was your interview, And you have quoted that the women of the family were to be taken to dachas near Kiev and then to the Rivne Oblast. Dacha near Kiev is not reflected in your declarations. What kind of dacha or townhouse do you mean? And what do you own in the Rivne Oblast, where you intended to take your family in the beginning of the war? Thank you for your question. Dear advisory group of experts asked me about the land plot. And this is the dacha that I mentioned about, because next to it there is the land plot of my wife, and we thought that we could stay there for some time and also to take my sister. So it's a townhouse, cottage house. Sorry, I have interrupted you. It's not a dacha house, it's a wagon. And you intended, we were supposed to bring our family and the family of my sister and to go all together to the Rivne Oblast. So this is not the immovable property, and it doesn't belong neither to you nor to your wife. No. And what do you have in Rivne Oblast? Where did you intend to go? Do you have some property there? My cousin, my wife's cousin lives there, and they have their own property there. And then in Ostrog, I went also to the enrollment office, military enrollment office. Konstantin Yurievich, you have worked in the administration of the president, but after dismissal, you worked in the Polish company. And you stayed abroad, according to our information, was 108 days. And during that time, you managed to make in Poland, according with your declaration, 56,280 hryvnias. How did you manage to survive with that amount and also to provide for your family at the same time with such little income? It's not quite right. 50,000, that's for another period. If you take a look at the declaration, it's another period. It's the beginning of 2021. 2 months. So in 2020, I got their income. In 2019, you have declared income from Polish company in the amount of 56,218 in 2019, and at the same time in the declaration you have submitted the declaration while you were dismissed from the administration of the president, and it was for 1 year. As of September the 10th of 2019, you have reflected not having any cash or funds. You have spent 108 days abroad as of September the 12th up until the end of December 2019. How, having no savings, did you make 56,000 per year? How did you manage to survive? Or did you have any other sources of income? No, I didn't have any other sources of income. Then how can you explain this? Savings, did you have savings? Okay, so your question, in September, you leave the president administration, yes? And then you submit the declaration and you indicate that you have no income. And after that, you work in Poland during 3 months, making 56,000 hryvnias there. So it's not clear how you managed to survive abroad. This is question 1. And question 2, How did you manage to exist 1 year with the amount of 56,000 hryvnias, having no other sources of income and no savings? Well, it's not quite right. In 2019, I still worked in the office of the president. I did have income. That's why I'm asking you this question. In the day of your dismissal, you have submitted the declaration where you have reflected zero income. This must be a technical error. I submitted what I did manage to make in the office. Well, we are using the data from your declaration, and it says that there was no income. Well, you can. I did have income, and it can be seen from the tax documentation. Or maybe this was some technical error, because it cannot be that I did not submit the information about my income, because they were legal in the office of the president of Ukraine. I see. But still, 108 days, that's 3 months of staying abroad, and income 56,000 hryvnias. How did you manage to survive in the foreign country? How did you manage to live from that money? Well, we have just talked about this, that I did have income. Let's check this in my tax information. So you had some savings for the previous period, yes. Second, I have reflected the income that I had, and apart from that, I was invited by the Polish company that provided me with the accommodation, and this is a really high level of provision. Like, they provided me with accommodation. I see. That's all from me. I will kindly ask to continue the interview with you, my colleague, Madam Maureen O'Connor. So if there is a need to stop the live broadcast, we are ready to do this. Well, it depends upon the questions, you do understand. So if it's necessary, it will depend. Miss Maureen, is there a necessity to do this, to stop the live broadcast?
Subject matter will be your term of service, your military service, and I have some questions that I'd like to ask.
I think better to close our hearing.
I agree.
Припиніть, будь ласка, пряму
Please suspend the broadcast. So we have already regained the broadcast live. Madam O'Connor, do you have more questions to ask? Allow me, Konstantin Yurievich, to ask you a few more questions. According to our information, as of April 2010, April 2014, you were the head of the supervisory board of the public joint stock company Gas Tech Service. In accordance with the U-Control service, 79.9% of the total quantity of shares of this economic enterprise belongs to the company that is registered in Cyprus. Cyprus, as it is known, the offshore zone. You were the head of the supervisory board. So does it say that the joint stock company where you were the head of the supervisory board had also intention to avoid the tax paying? And what is your attitude of this as the head of the supervisory board? No, not like this. I disagree. So first of all, this was the corporate decision of the groups of companies, Katahan Petroleum, where I used to be the chief legal advisor. And they had their assets here in Ukraine. They kept their assets here in Ukraine. We are speaking Agronafta Gas Tech Service. You were a member of the supervisory board of this company. I was that because I was the chief legal advisor in the group of companies Kadahan Petroleum. One of those companies, of Cyprus companies, was the company that was part of this group. Has this company decreased the taxes? I'm so sorry. So those who own 80% of shares is registered in offshore. So have they underestimated the taxes? No, because this is the transparent company. Kadahan Petroleum shares, they were on the London Stock Exchange in the open space. So any underestimation of the taxes would lead to criminal processes against management. I see. One more question. In 2021, you have indicated in your declaration that together with your wife, you own 21 shares of the Institute of Kiev Urbut company. But altogether, in accordance with the U-Control service, this company has 10 factors which speak about special attention to it, this joint stock company. Okay, thank you. These were the shares that were received in the mid of 90s in the process of privatization. So basically, no, they have no impact on the activity. Frankly speaking, I don't even know where these shares are. Next question. In March 2016, you referred to the law enforcement agencies and reported that some woman called your phone, informing you that the unknown persons, she gave $3,000 bribe to some persons to be given this to you so that you would employ to the office of the president her son. Is that true? I reported, yes, about this fact. How did this case end? I answered the similar question for the Competition Commission, and I don't know. I just reported this information to the law enforcement agency. Where did this woman take your phone number? I have no idea. This could be a provocation. I see. In 2020, Anticore publication informed that, according to the results of the journalistic investigation, it was identified that one judge who participates in the qualification assessment, and his property status is not in line with official income. And altogether, you recommended this unfair judge. How can you explain this? That you recommend the judge whose property status is not in line with his official income. Mr. Kaposh referred to me with the suggestion to include me into the list of one of the recommenders. Did you know this person, Mr. Kaposh? Yes, I knew him. Did you know about his way of life? I knew him as a professional, the legal expert, and because we used to work in the Ministry of Justice. And did you know that his way of life is not in line with his declared income? I did not know. The question was like this: can you give me the recommendation about my professional activity? Why are you giving their recommendations without making sure you know this person very well? I did not provide the recommendation. I just agreed that this person can include me into the list of those who can be the recommender. We are not discussing which recommendation I have given him. These are two different things. I see. One more question. Analyzing your declaration that you have submitted for the competition for the position of HQCJ, the certain divergences were identified by the National Commission. So how can you describe them? How can you explain them? They were minimum divergences, and they were connected with the fact that at the moment when I submitted this declaration, I was using the declaration that I have submitted in the beginning of the 2022 year during the competition for the participation to the higher corpus of the state service. And at that moment, there was no certificate about tax, so tax information about my income. And since in August I had no chance to check this, so I used the declaration that was submitted in the beginning of in the beginning of 2022. I see. Konstantin Yurievich, your motivational letter, in which you have specified that you have your own direct experience of work in the bodies that were taking care of the making amendments to the Constitution of Ukraine, and the position of the Secretary of the Council for 5 years. You were part of the process of initiating, establishment, approval of new norms that further on became part of the main law of the state. This is the quote of your motivational letter. And it is indeed true, you were directly involved to the implementation of this judicial reform. Maybe you were not the first phase, maybe not even the second, but not the last one. Not the last phase of this judicial reform. So tell us, please, at that time when you have become the secretary of the council of this judicial reform, and then you held the position in the office of the president, did you have your own experience, direct experience of work on the initiation, establishing, or approving new norms of law? Yes, I did, since I used to work in the Ministry of Justice, and the position was the head of the main department for the representing interests of the country in other jurisdictions. This was the newly established department, and we have initiated certain norms, both like the decree of the president about the interaction of the state bodies, and on legal answers to such claims. That's as a minimum. Konstantin Yurievich, as of April 2014, you were unemployed. And in October 2014, you held the position of the Secretary of the Council on Judicial Reform. How can you explain this? Why? Due to which personal characteristics or friendly relationships, and if so, then with whom? How was this job opening offered to you right away in the office of the President of Ukraine? We are speaking about the Judicial Reform Council. It's not Office of the President. Oh, I see. Okay. Yes. The thing is, we all remember 2014. Yes, it was after the Revolution of Dignity. The window of opportunities for reforms. I have American education, public administration. I have always wanted to do this job, to be involved in this public administration work. And the NGOs, I mean the professional association, encouraged the graduates of the Western universities to go to the National Council of Reforms, to the Verkhovna Rada of Ukraine, to the Office of the President, to the ministries on those directions that were in the professional understanding, the directions that could still be developed, to join in. They were encouraged to join in, to give their suggestions. That's why I joined the working group of the National Council of Reforms, I see. And you were noticed there, and that's how you got this offer. Yes, yes. So, but it was unpaid. Yes, it was not paid. And then in December, you were appointed for one of the managerial positions in the Office of President of Ukraine. This position of which category? B. B. Did it require to participate in the competition? As far as I remember, in accordance with those procedures, I managed to undergo them. So you did go through the interview, yes? Yes. And you participated in the competition. But which competition? Who else was the participant to the competition? It's hard to tell about this now. This was 10 years ago. As far as I remember, the job opening was officially open and people could submit for this competition. Who made this decision? Who filed or who applied for this position? I had the interview with the deputy head of the Office of the President. I had the interview with another deputy of the office, two deputies, and also the interview with the representative of the president in Verkhovna Rada of Ukraine, and with the head of the administration, head of the office. Konstantin Yurievich, in accordance with your job description, functions of the head of the department, so the position that you held, you are appointed and dismissed on the application of the head of the administration of the president. Also, the head of the department subordinates to the deputy head of the office of the president. Who was this deputy head? Alexei Filatov. Did you know him before? We had some joint work in the legal firm, Proxenov, in the period as of 1999 till 2002. Do you see here some conflict of interests that the person that you used to work with in one company now invites you for the position to become their subordinate in the office of the president? No, I do not. We worked as of 1999 until 2002. And in the legal circles, yes, we knew each other, we were familiar, but I have shown myself well in the work of the working groups, and the fact that we knew each other is just the fact. It's just the fact. Okay. You have obtained a significant experience of work in the office of the president on the reforms of the judicial system of Ukraine.
I remember the conclusion of the Venice Commission as of March of 2015. And this opinion in particular states that, as informed by representatives of public authorities of Ukraine, the situation in the judiciary of Ukraine is characterized by the following factors. Firstly, a low level of professional competence of sitting judges. Secondly, a high level of corruption in the judiciary. Thirdly, high level of political influence on the judiciary, which altogether has resulted in the key fourth factor, that is a very low level of public trust. This situation in the judiciary of Ukraine has been qualified as extraordinary by the Venice Commission, which called for adoption of extraordinary measures. But even in this situation, the Venice Commission stated that it would be inappropriate to dismiss all the judges of Ukraine, which was actually discussed in Ukraine, but as an exception, taking into account the extraordinary nature of the situation, it was necessary to conduct qualification evaluation of all sitting judges. Don't you think that from the perspective of a reasonable external observer, there might be an impression that representatives of public authorities of Ukraine brought the Venice Commission to this particular recommendation, and so that it would allow to implement this particular reform by means of conducting qualification evaluation of all sitting judges, among other things. Let's clarify the question. What would you like to hear from me? About what? You were one of the authors of the judicial reform, and you, as the author of judicial reform, now have a question. Won't a reasonable observer have the impression that while informing the Venice Commission about this particular situation in the judiciary, you actually brought it to the provision of the opinion that you were expecting? Back then, it was the discussion of the necessity to resign the to dismiss all the judges, or at least to conduct qualification evaluation of all sitting judges. No, that's not accurate. If we look at the strategy of reforming of the judiciary and other legal institutions, the position of the Council on the judiciary reform was actually about objection against dismissal of all judges. The issue of qualification evaluation was the issue of the dialogue between the society and between different public authorities. The Verkhovna Rada, as the political tool, tried to determine its political goals. Accordingly, the Council on the Judiciary Reform tried to have the least painful transfer from the situation which existed in 2014. Why did it exist in 2014? That's the result of the Revolution of Dignity, when judges actually were adopting verdicts against people for nothing. So that was the position of the Verkhovna Rada and of the civil society back then. If we look at these discussions with the Venice Commissions, if we look at these discussions with other international organizations, and if we look at discussions inside the Council of on the judiciary reform, then we see that the correct path was chosen, which resulted in a quite relevant decision with respect to the reform of the judiciary, including conduct of those reforms about which we are talking right now. Okay, I understand you. Konstantin, going back to qualification evaluation. What was the need to introduce this particular method of qualification evaluation, including the check of theoretical knowledge through testing, practical assignment for sitting judges, check of stress resilience by psychologists? when we are talking about a sitting judge who has worked for 10, 20, 40 years, isn't it enough just to check the level of theoretical knowledge, the capacity to produce the practical assignment? Can't court decisions of the judge, complaints against the judge's actions or lack of actions, wasn't it enough to consider these materials to determine whether the judge was sufficiently competent, sufficiently stress resistant? Experience of which European country was used when Ukraine decided to implement this method? Thank you for your question, but why should we here follow some experience? We created our own path as a reform using experience of different countries. What was the need to have this particular method? Wasn't it enough to consider materials that were available in order to evaluate the sitting judge? For example, the professional experience of a judge would be 20 years. Wasn't it enough to decide whether the judge was competent and stress resistant? You probably remember discussions at the meetings of the Council on the Judiciary Reform, and probably you remember that some people were saying, and some representatives of the civil society and representatives of international institutions which were conducting monitoring were saying that some judges saw the code for the first time when they started preparing for the qualification evaluation. We can debate about that for a long time. It was the demand of the society, it was the demand of the revolution of dignity to bring judges into the level of independence and political neutrality and competence, which would allow to talk about renewal of the judiciary. Even nowadays, I have 35 years of legal experience, and I come here because this is the demand of the society, to come here and to tell about myself. Konstantin, after all, you are referring to civil society activists, so they criticize authors of the judiciary reform, for example, that during the creation of the Supreme Court, 44 judges, in their opinion, lack integrity, which is almost a quarter of all judges working in the Supreme Court. How could it happen like that? They demanded that, you heard them, you implemented this reform, but as a result they are dissatisfied because there are so many judges lacking integrity. That's a question not to me, but to civil society organizations. Moreover, I would like to tell you that 44 is not correct number. According to our estimates, some issues could be raised with respect to 70 judges. I'm talking about controversial questions, and those questions could be studied from different perspectives. I don't believe that 44 judges who have passed through this competition are so dishonest and lack integrity so much. We need to look at everything in the context. A person who has passed, who was recognized as having integrity, but everything can change one day. Konstantin, again, there are many surnames mentioned in the society. When we are talking about graduates of the Kiev Institute of International Relations, and President Poroshenko was the graduate of this institute. Kozyakov, the chair of the HKCJ, also graduated from that institute. Filatov also graduated from that institute. Many lawyers of Vasil Kysyl and partners who became judges of the Supreme Court also graduated from that institute. So was this institute sort of the place where judges were prepared, or maybe there was some external influence in order to make sure that the Supreme Court is filled with such lawyers as judges. Thank you for your question. I'm a graduate of Kharkiv Yaroslav Mudry National Law University. That's a question to you as one of the authors of the judiciary reform. Yes, you are not the first or the second phase of the reform, but you are not the last. How could it happen like that? Just like graduates of Kharkiv Academy or the legal department of Kyiv University, they are graduates of one of the best universities. Okay, clear, thank you. You mentioned civil activists about their voice, which you was necessary to hear, and that's of course true. After all public authorities and courts serve the society. And representatives of this society have the right to observe and monitor activities of public authorities, express their preferences regarding improvements in their functioning, express their comments regarding this work. And such public authorities, including courts, have to hear the social demands, and they should find the opportunity to respond to these social demands by means of improving their functioning. Because, again, I would like to remind you that they serve the society. After all, representatives of the society have the right to participate in decisions regarding HR decisions in public authorities. Hasn't it happened like that? That as a result of this judiciary reform. For example, let's take the High Council of Justice, 21 members, including 10 appointed by judges, 11 member is the President of the Supreme Court as ex officio, and the rest are appointed by the President of Ukraine, the Conference of Prosecutors of Ukraine, the Conference of Academics of Ukraine, the Conference of High Legal Universities, and those representatives of the civil society. So, in connection with this, why was it necessary to create one more body, one more institute, the so-called Public Integrity Council? And maybe we could agree that there was such a demand in the society if their members were people who enjoyed public authority, who could lose their authority in the society. But members of this body were persons who were unknown to in the society before that. Can you please tell us? Questions about the methods of their work is not a question to you, but you, as one of the authors of the reform, what was the need and which experience of which country was used while creating this additional body? Wasn't it enough to have representatives of the civil society in judiciary bodies? Look, the new formation of the High Council of Justice and finding the balance and formation of the HQCJ was the question of the public organization of these judiciary governance bodies. And yes, really, our constitution hears the voice of the society through these representatives, representatives of the professional legal community. The question about the Public Integrity Council, as you remember, was discussed since the very beginning of a discussion of the strategy of the judiciary reform and reform of other legal institutes. In order to understand whether it was necessary to have this direct voice of the civil society, which was heard at Maidan. Okay, clear. So, not indirectly, but directly, yes. And the discussion, the meeting of the Council on the Judiciary Reform, the search for this form resulted in that. Okay, thank you for your answer. Konstantin, you were the secretary of the Council on the Judiciary Reform. I remember how this council was working. They had meetings twice or 3 times per week, and they discussed very thoroughly amendments to the Constitution. Each phrase, each word was debated, discussed, and voted for. In turn, when the draft law on introducing amendments to the law on the judiciary and the status of judges was prepared, the new version of that law. For some reason, all of these processes were secret and closed. And I will not tell you a secret when I remind you that for the first time, discussion at the Council on Judiciary Reform, the secretary of which you were, was held on Friday. And even without discussion of the final and transitional provisions. Take into account some comments expressed on Monday. It was registered with the Parliament, and then there was the possibility to look through the transitional and final provisions, and on Thursday the Verkhovna Rada voted for it. Can you please tell us, when amendments to the constitutions were discussed, everything was held publicly, openly, but when the draft law on introduction of amendments to the law on the judiciary and the status of judges was prepared, the practice changed. What was the reason for that? Look, several times amendments to the law on the judiciary and the status of judges were considered at the Commission. They are showing the time that we've exhausted the time, but let me answer, please. Look, there were several instances when we discussed the amendments and amendments to the law on the judiciary and the status of judges were submitted to the Verkhovna Rada several times as well. For the first time, it happened in the form of the law on the ensuring the fair trial right. Yes, I understand. I'm talking about that. That there were discussions there. For the second time, no. So at first we discussed the strategy according to which we had some strategic objectives which allowed introducing some amendments, and those were the agreements. Based on these strategies, the law on ensuring the fair trial right was developed, and the law on introduction of amendments to the law on the judiciary was also developed based on that. Okay, thank you. My colleagues are emphasizing that we've exhausted our time, but I would like to ask one final question about liquidation of the Supreme Court. We discussed with you what became the ground for the judiciary reform, these 4 indicators, right? The high level of corruption, low level of professional competence of judges, a high level of political influence, and low level of public trust. Which of these indicators became a ground for adoption of the decision on liquidation of the Supreme Court of Ukraine? And a follow-up question, why liquidation of the Supreme Court of Ukraine happened in such a way? You could not but understand, and it was later on confirmed by the Constitutional Court and the European Court of Human Rights, that that was the constitutional body and it could not be liquidated through a simple law, especially given that it was not in the text of the law but in the final and transitional provisions.
I have a question, because now I see that there's a kind of ping-pong.
I would like to terminate
exactly,
this.
I think that it was a role of the Parliament to decide on the law. Yes, we have to put just question. We have to verify the integrity of the man. Yes. So for that reason, I think that sometimes the
Питання
questions
зводиться до того,
are going to-
що кандидат мав відношення.
The candidate had a relation to this judiciary reform. That's the reason for my questions, and we want to check the candidate's diligence during preparation of this reform and his honesty in his current answers. Yes, it was the role of the Parliament, but the draft law was prepared by the Council on the Judiciary Reform, and our candidate was the secretary of that council. Can you please answer my questions? Yaroslav, I will answer this question. On the one hand, it is a difficult question, but on the other hand, it is very simple. The European Court of Human Rights and under Humaniuk and others versus Ukraine case, and the Constitutional Court in its decision said that the constitutional body was not liquidated. The Supreme Court is the constitutional body according to our constitution. There was liquidated the legal entity. The legal entity was liquidated. We can debate for a long time about this, but I believe that on the basis of Homeniuk case and on the basis of the decision of the Constitutional Court, this problem has been resolved.
What was the need? High level of corruption, political impact, insufficient professional level. Item 12 of the transitional provisions of the Constitution, because it is not Supreme Court of Ukraine, but the Supreme Court of the Ukrainian USSR. So do the other members have questions, please?
This gentleman was part of a decision making. He was not the sole decision maker on the Supreme Court, a dissolution or reconstitution. So I'd like to move on and ask if there's any other questions by any of the members.
No, there's no, and I suggest that we give the candidate time for final remarks.
Yes, I agree.
Шановні члени,
Ні, так я хотів запитання задати.
I wanted to ask a question. I wanted to ask the question. Mr. Konstantin, you run for the position of the judge of the Constitutional Court. You mentioned that you had the American education, and that thanks to the American education you were invited, or that it somehow had an impact on your career in the office of the president. Tell me, please, in which American university they teach to violate the Constitution, to make illegal decisions, so that afterwards the Constitutional Court of Ukraine would abolish them, and the European Court of Human Rights as well. So, do you feel your guilt in this part for that judicial reform that you had to implement? This question number one. And question number two. You mentioned that one of the reasons of the reform, when the courts make judgments for nothing. Can you give at least one example of the illegal sentencing of the person by the Supreme Court?
I must inform my colleagues that we far exceeded the time envisaged for this interview. So I will not allow any further question, and I will invite the candidate to provide the final remarks. But please, if you want, you can answer these two questions of the member of the advisory group of experts.
I will answer a question, and after that I will go to my final remarks. Я не зовсім погоджуюсь.
I do not quite agree with the interpretation of the things that I mentioned. I did not say that the Supreme Court made some illegal decisions. We have to go through each individual case, and this is the question for the response of the society to this or that question. A very complex is the matter of the two Supreme Courts, so to say. There is only one Supreme Court, the constitutional body. The former legal entity, the Supreme Court of the USSR, is the legal entity, but the Supreme Court could be not the legal entity, but the secretariat of this court could have been the legal entity. But this is a matter of discussion. Therefore, we can talk about the results of this reform, But in any case, we cannot call it, ridiculous, because we managed to solve all of the problems that we had in the case of Salov, Volkov, Ukrtrans, Auto. These questions were removed by the Council of Europe. This tells us that on the level of the legislation, we achieved the results that were ahead of us, in front of us. And on the institutional level, we also managed to achieve certain results. At the moment, we are trying to continue the reform also together, sitting here on the level of the people. For me, it's very difficult to be sitting here and to be open for the entire society, telling about all my achievements, because I have certain reputation and I'm trying to preserve it, to keep it. And this is very important, that if the reputation is solid and valid, and we do have some situations in when we can say that the reform is ongoing, it still continues. I'm sorry, I will move to the final remarks, to the closing statement, and I would like to express my gratitude for the objective, multifaceted study or examination of my candidacy. It was hard for me, but I think this is the another form of this reform that took place. And I would like to make sure the advisory group of experts and the public that my knowledge, skills, and professional experience in the sphere of law allow me to pose questions about the reasonability of my intention to become the judge of the Constitutional Court. And there are two important factors to mention that influenced my perception of the role and position of the Constitutional Court in the sphere of the protection of the main law. First, it's my thesis study. I have successfully managed to define the problematics of the problems of the humans in Ukrainian institutionalism. I clearly realized that natural rights of the people is something that exists irrelevantly from the state, that it's given to the person by the fact of its birth, their birth. But it depends upon the state how the natural rights are reflected in the legislation. And most importantly, how they are implemented in practice. Factor number 2. My current professional activity is connected with the protecting interests of the state, of my motherland, against external aggression. And I have realized how important it is to provide the independency and territorial integrity of Ukraine, to preserve life and health of our citizens. In the position of the judge of the Constitutional Court, I will be taking care of the protection of the main law. I will be doing my work properly, aware, and responsibly. And finally, I would like to make a quotation of the famous legal expert, the member of the Supreme Court of the USA, Ruth Ginsburg, who once said, "Constitution is the rock our nation is supported by. We ought to preserve its principles and to defend its values." And I completely agree with this vision. Thank you for your attention.
Thank you very much for providing the answers to all the questions and to share with us also your view on the issues ahead concerning the Constitutional Court. So you may now leave this room, and we end this session now. Thank you.